Senator Hughes, you would agree with me that if an organization has been adjudicated as violating civil rights or constitutional rights, that they should not, and an individual is still contributing to that organization, then that individual associated with that organization shouldn't get the benefit of your bill. Would you agree with that?
So
if there's an adjudication.
It doesn't sound like a group like that would qualify under this definition. That's certainly the intent.
Well, why wouldn't they qualify?
I don't think the Fellowship of Christian Athletes or the
I'm not talking about
Salvation Army or your church or mine would fall under a category like that. But I want to make sure I'm following you.
I mean, why wouldn't they fall under a category like that?
Because do you believe, I may have misunderstood.
I think you did.
I don't think those groups have been adjudicated as, I'll listen
okay,
more
so
carefully. Go ahead.
Based on your definition, religious organization means an organization that is a religious organization under 110 of the Civil Practice and Remedies Code.
Yes, sir.
That has a 501c3.
That's part of it, yes, sir.
Right, okay. So if you have an organization described like that, and that organization has been sued, and there's been a determination that that organization has violated civil rights. Let's just say civil rights.
All right.
Okay? That they violated LGBTQ rights. And it's been a final determination.
All right.
You're not telling me that a person that continues to contribute to that organization should get the benefit of being able to provide, provided the coverage of your bill, are you?
Senator, a group like that shouldn't qualify under the definition. And that's part of the reason we want to put the definition in here. Otherwise, it might be a vague term because anyone can claim, as you know, and use that as a cloak. But that's part of the reason we want to put the definition in to make sure that we're staying on the original intent.
Well, but
is that what you're talking about?
But you said they shouldn't qualify.
Oh, that's right. That's right.
Based on what you're saying, they would qualify. Okay? I mean,
I don't see how they would, but go ahead. I'm listening to you.
Okay. Well, they're a religious organization. Their purpose is a religious purpose.
All right.
And they're 501c3. And I think those are the main elements that you have quoted in the Practice and Remedies Code, correct?
And just so you know, when I didn't write that, we took that out of the code that was passed about 20 years ago. But go ahead.
I'm not saying you wrote it, but I'm saying that's the definition in law. Is that correct?
And it's in the civil rights section, and I get the impression it was put there for this purpose, so that folks wouldn't try to cloak their evil acts, you know, and shroud them with religion. But if I'm understanding you correctly.
No, that's the impression that you get. I'm talking about the black and white law.
Yes,
the
sir.
law is that an organization like that would be protected under your bill.
Only if there were such an organization and if they qualified under the definition, that would be the only way.
That's exactly what I'm saying. So my point is this.
Okay.
If you have an organization that qualifies based on that definition, and you have a person that's contributing to that, you have the organization.
All right.
The organization has been adjudicated.
All right.
And for adjudication for our members is found guilty.
Yes,
okay,
sir.
of discriminating against the LGBTQ community or an individual within that community. And you have a person that is trying to get a contract with a governmental entity.
Right.
Right? Okay? And they continue to, after there's been an adjudication by the court of discrimination, that person continues under your bill to contribute to that organization. Do you believe that individuals should be able to still get protection under this bill?
They would not. And let me tell you why.
All right.
They would not. I want to make sure I'm being precise. It says the organization does not engage in activities that would disqualify it from tax-exempt status under 501c3. 501c3, charitable, religious. A group having been adjudicated to have done the acts you're describing would not qualify. Their activities would not qualify under 501c3. And let me be clear, Senator, it doesn't just say they have to they may have a 501c3, it hadn't been revoked yet, but if their activities would disqualify them, they are disqualified under this statute. And I want to make sure we're clear on that.
Well,
so a finding of intentional discrimination like you're describing would clearly be activities that would disqualify them from 501c3 status.
okay, Senator, I disagree with you. Just because there's been a determination that they've intentionally discriminated doesn't automatically doesn't automatically, as you well know, Counselor, doesn't automatically make them lose their status.
No, Senator, let me be clear. They don't have to be revoked. It says they cannot engage in activities that would disqualify it. So if they've been found to have committed these acts, that activity would disqualify it, whether they've been revoked or not. If they've done those activities, they're out. And I'm just thinking that's why they drafted it the way they did back in '99. I wasn't here.
Well, again, Counselor, Senator.
Yes, thank you.
Both
are fine. Thank you, Counselor.
There would have to be a determination. Okay, someone would have to. Well, I mean, it's not automatic.
Oh no.
I mean, you would agree with me. You would agree with me that it's, just because it says that in the law, that has to be some due process involved to make that determination.
The plaintiff.
Would you not agree,
Senator? The plaintiff has to prove their case. The plaintiff has to prove their case. So, someone like you're describing, they've given this organization, and it's been adjudicated as having discriminated against someone's rights. That person would have to show that I gave to them, and they qualified. And one of the disqualifiers is they engage in activities that would disqualify from tax-exempt status.
Okay, let's just say.
I want to make sure I'm saying that right. Sir?
All right, so we're on the same page. So then there shouldn't be a problem amending your amendment that basically says that if an organization is adjudicated as violating some civil rights laws, then that's prima facie cause to say that they are no longer eligible. Wouldn't you not agree?
Senator, the language already in the amendment covers that, and it covers situations we couldn't even think of. That's why the amendment's drafted like it is.
So
let me just say this respectfully. Okay. In this definition, the inclusive language is pretty descriptive. Primary purpose and function, religious. But then the language that excludes is very broad. If it engages in activities that would disqualify it from tax-exempt status under 501c3, they're out. So a person like that, they're not going to get past that motion to dismiss because they would not qualify under this definition.
So you don't
Again,
mind,
the definition.
Okay, so we agree with that. So you wouldn't mind making it just a little clearer, given the fact that we're not trying to discriminate. Can we put in there including but not limited to?
Senator, it's already included here. You know what I'm talking about. It's already included.
Yeah, you know what I'm talking about also. Because again,
I do.
I mean, I think that if it's not the intent to discriminate or allow individuals to get to be shielded by discriminatory organizations, we surely could put something in there, including but not limited to.
Senator, it's in there. If they engage in activities that would disqualify it from tax-exempt status under 501c3, they're out. I mean, that's very broad language.
Okay, then let's go down this path for a minute.
All right.
Okay, what qualifies under 501c3 in terms of losing your exemption?
So as you know, of course, we can talk to experts, but 501c3 is charitable, religious, educational, right? It's not political. It's charitable, religious. It's not discriminatory.
So I'm saying, what activities qualify though?
Charitable activities, religious activities.
No, I'm sorry, I said that wrong. You said they would lose their tax exemption. Read that phrase again.
Okay, so a religious organization is one that, I'll quote, does not engage in activities that would disqualify it from tax-exempt status under Section 501c3, and it goes on as it existed in 1999.
And so what activities are those that would disqualify someone from 501c3?
There are many activities, Senator, that would show that you are not actually a religious organization. If you're engaging in invidious discrimination like you've described, if you're engaging in other activities that are not religious, not charitable, and then, you know, that's what the code is.
I'm focusing on discrimination. I have not seen a case where an organization that's 501c3 that had a finding of intentional discrimination has lost their tax-exempt status. Have you?
Senator, I'm not aware of an organization that's maintained 501c3 status that has been found of that. Do you have a case where they've been able to keep it?
That's the very reason I'm asking you to put this in there, because I'm not aware of an organization that you've defined that have lost their 501c3 status because they've engaged in discrimination. That's why I'm asking you, have you seen a determination by the IRS that's done that?
I want to be clear. Under this definition, they don't have to lose their 501c3. All they must do is engage in activities that would otherwise disqualify them. So to make sure, this is a broad category, right?
Well, again,
Whether the IRS takes action or not, if they've engaged in an activity like that, they wouldn't qualify under this definition.
Under what authority, sir?
I'm sorry?
Who makes that determination? I mean,
Well, the IRS, they make, of course, you've done those applications for, those long applications for churches and charities, and to gain that 501c3, sometimes an accountant has to help, but, it's pretty detailed.
Well, out of all due respect, we go on and on about this. I know that you have the votes, but members, you need to think about this. You need to think about this. The reality is that the only thing I'm asking is to modify this amendment to basically say, including but not limited to, discriminatory action and adjudication. And an adjudication basically means that the court has found that the organization has engaged in that type of activities. And so we want to make certain that persons that continue to contribute to those organizations as defined by the Practice and Remedies Code don't get the benefit of this particular bill. But if a business wants to terminate or not provide them that particular bill, they'd be able to do that because the person continues to contribute to an organization that has engaged in discriminatory actions. The only thing I'm trying to do is to modify that particular provision in your bill.
No, I understand, Senator. The language here is broad, and whether they've been denied their 501c3 or not, if they engage in that kind of activity, they're out. And again, you and I know, but I want to make sure I haven't missed this. The person claiming the protection of this law, they've got to prove their case, right? The government doesn't have to prove they didn't do wrong. The person claiming protection of this law has got to prove they qualify. And I think we're covered.
No, I understand exactly what you're saying. And what I'm saying also, and I won't belabor the point, is that if the members believe that a person that is a member of an organization that has a pattern of discrimination, has been adjudicated as discrimination, of discriminating, should still get the benefit of this particular bill, then so be it. Vote your conscience. Thank you.
Thank you, Senator.